All right, good morning, everyone. Are we live?
Right.
Okay. It's just a couple minutes after 9:30. I think that we should get started. For the record, I'm Colette Peters. I'm the Director of the Department of Corrections and Chair of this work group on corrections healthcare costs. It sounds like we have a couple of people joining us on the phone, so why don't we start there?
Hi, this is Kelly Ballas. I'm the Vice Chair of the work group, and I am the Chief Financial Officer for the Oregon Health Authority and the Interim Administrator of PEB and OEB. Good morning.
Thank you for joining us with all of those hats, Mr. Vice Chair.
You're welcome.
And this is Julie McFadden, and I'm Senator Bates' legislative aide. I'm sitting in on his behalf today.
Thank you so much. Anybody else on the phone? Great. Senator Winters, will you kick us off with introductions, please?
Senator Jackie Winters, the one who sponsored the legislation to get us organized. How's that?
Perfect. Ms. Botkin?
Mary Bodkin with AFSCME.
Celia Howes with the Oregon Criminal Defense Lawyers Association.
Glad you're here.
Good morning, I'm Chuck Sparks. I'm with the Multnomah County DA's office and on behalf of the ODAA.
Great, thank you.
Good morning, Fairworth Paxarash, Oregon Youth Authority.
Good morning, Washington County Sheriff Pat Garrett.
Morning, Carl Miller with AOCE.
Great, thank you. By way of introductions, I will just say that as we looked at the timeline that this work group established in order to accomplish this grand review of our healthcare program at the Department of Corrections, we really are on target. So I want to thank you for everyone's commitment to these meetings, be it in person or on the phone, to really keep us moving along. If we are able to get through our agenda items today, that will allow the next meeting to have us review a draft report of the work group's discussions and then finalize it at the following meeting. If you remember last time around, we didn't have that opportunity to review it in person, and I think that this discussion will really benefit from that. So again, if we're able to stay on target today, we will have some real time to review our recommendations to the legislature. And with that, I will turn it over to Steve Robbins, who's going to kick off the presentation this morning.
Great. Good morning, Madam Chair, members of the work group. For the record, my name is Steve Robbins. I'm the Health Services Administrator for the Oregon Department of Corrections. I'd like to begin this morning by providing you an update, as we've done in previous meetings, on Medicaid data that we've compiled. This is a chart that you've seen before, a table you've seen before, but this just have updated numbers. So far, we're up to 226 inpatient events that could potentially qualify for Medicaid coverage. We've submitted 185 applications. So far, 130 of those have been approved, so the other 55 are in pending status. So far, we've reported back that we've had no denials. In this case, we have gotten our first denial, but that's not written in stone at this point. We're still working with DHS and OHA on that one, so that one may turn back into a zero. That's our hope. And then we do have applications, as we always do, that we don't submit because we know before the fact that they aren't going to be approved. 16 of those were for no birth certificates, 9 for no assets, and then we have ICE detainers and other issues on there as well. Now, the two lines on here that are in green are about claims, specific to claims. And just as a reminder to the work group, $12.7 million was removed from DOC's budget in anticipation of Medicaid savings. After 6 months of operating, the information we've received from OHA is that they've paid approximately $700,000 in claims. Now, please remember that the savings is greater than that, because this is how much we've paid at a Medicaid rate, not how much we've saved by not paying at a commercial rate that we would normally pay. So at this point, we're estimating that our savings are still hovering around $2 million at this point. So if we assume that it's about $2 million, that puts us on a glide path towards about $6 million worth of savings for this biennium, which is great news, but it's not the $12.7 million that was removed. So we're working right now with the Chief Financial Office and the Legislative Fiscal Office as we get more information and as it becomes available, so we can ask for modifications to this reduction, both for this biennium and what's already in next biennium's reduction.
DA Sparks?
Thank you. Mr. Robbins, I just had a question about the instances where there is no birth certificate available. Are those because those are people without documentation in the system, or are those efforts, are there efforts to achieve their birth certificates through the counties?
Chair Peters, Ms. House, yes, there are a wide swath of reasons why we can't get birth certificates. Most cases, in this case, that they're not because they're undocumented. These are folks that were born in other states. They've moved around a lot. In some cases, it's difficult for us to even find out what county they were born in. But we have a whole machinery internal to the Department of Corrections to work through that, and we're trying to get those as fast as we can. And we're actually moving that process up closer to intake so that we, instead of trying to solve this problem on the back end, will slowly but surely start working this problem up towards the front end.
Great, thank you.
DA Sparks?
Thank you, Chair Peters. Steve, we see the number of off-site inpatient events. So I'm wondering, does Medicaid in any way, shape, or form reimburse DOC for on-site medical events that are inpatient in nature?
Chair Peters, DA Sparks, the answer to that is no. Right now, and just to be clear, we're not receiving reimbursement from Medicaid in these situations. The providers are actually billing Medicaid directly. So in these cases, it's almost a Y in the road. The providers are actually going directly to Medicaid, getting pre-authorization there, and those are being paid. If in fact they don't pay or deny the claim, then it is rerouted back to the Department of Corrections, and we run it through the process that we have traditionally run it through.
Follow up to that, is there some sort of legal bar that Medicaid has in place? For example, could the DOC somehow become a certified provider so that you could receive those payments?
Chair Peters, DA Sparks, the answer to that right now is no, because the CMS, the Centers for Medicaid and Medicare, have been very specific in the fact that when folks are incarcerated, their ability to be a part of it is actually terminated. Now, we've been able to change that to just put them in a suspended status so that we're able to move them in and out as they move off-site or on-site into our system. But as it stands right now, we are not in a position where we want to be a billing entity as the Department of Corrections.
Just a follow-up to this particular issue, and it's one that we as legislators have wrestled for years. It's also true of state hospital. It's any institution that the states are responsible for. The individuals are not eligible for Medicare, Medicaid.
Thank you.
Thank you. Director?
Steve, as you look at the claims paid or the savings, has it been consistent over the course of the past 6 months, or are we seeing more in the latter months? The reason I ask that is because it takes a while to get programs going. So when you talk about the $2 million, is it considering that lag in the initial months?
Yes, Chair Peters, Director, I originally had talked about this in previous meetings as a bulge in the snake. It was starting to build up, and we thought it was going to clear through. What we're finding is that it's not clearing through all in one fell swoop, but it's bulged out and now is starting to clear through. So we've absolutely seen a ramp up over time. Mm-hmm. I think that was one of perhaps the oversights in the original $12.7 million reduction, was that it assumed we were going to be going at a full clip right from the very beginning. And the complexities in this, we've learned that this is something that we're ramping up, and as we're starting to reach a plateau now, and we're starting to see the process really roll through. So my hope is in the next two presentations, even though we'll be kind of wrapping up the work of this work group, I'll be able to give updates on how that is continuing to progress.
Okay, thank you.
Thank you.
Steve, just quickly follow up. And I know other states have been grappling with this particular issue, and if we can find any loopholes around this in order to actually get payment from CMS. How many other states are doing what we're doing now? Do you know?
Oh, Chair Peters, Senator Winters, I don't remember off the top of my head. We've reported on that in the past, and I can get that information for you. But I think we're finding a vast majority of the states are now embarking on this. The nice thing is that in many cases with healthcare and correctional healthcare, we are in some ways leading the way, and so we're receiving calls from other states asking us, how in the world are you able to do this? Because we're running into problems, and the problems they're running into are very similar to the problems that we've experienced as we've gone through this.
Thank you.
Okay. As a second follow-up item, the topic of legislatively mandated exercise programs. Just as a reminder, DOC Operations Division previously provided testimony that according to a survey that we conducted at DOC, that no other states around the nation are reporting the use of any mandatory exercise programs. But a question did come up around voluntary exercise programs. And so this slide provides a sample of some of those programs. It's important to remember that this list and this sample are activities that are more organized in nature. But I would also like to point out that inmates are exercising on their own as well, in their cells or out on the yard, and depending on who the inmate is and the activity that they're going through. As an interesting side note for us, with these activities is that they also result in injury. And our medical staff has to treat those injuries in the course of daily operations, just like we would in the community. Unfortunately, with no electronic health record at this point or an EHR, I can't report specifics to you, but that's one of the things that's exciting to us about having an EHR is the ability to start to drill down on what types of activities were occurring so that we can then make some policy decisions about what the offerings are and how we go about allocating resources inside the system. As a third follow-up item, I'm pleased to update the work group on the status of a previous recommendation regarding the creation of a legislative remedy for House Bill 2087 to solve the suspension versus termination of Medicaid eligibility issue. Just as a reminder to the group, this was a request to update 2087 that would alleviate the need for DOC to reapply for Medicaid of inmates on an annual basis. DOC has supported the Oregon Health Authority and the Department of Justice in finalizing a legislative concept, and we wanted to update this group that that has been completed and has been submitted. And finally, on updates. Oh,
Yes, Ms. Bodkin?
Can we bounce back? I know that the electronic health issue is like a big deal for the department. Do you anticipate having legislative action on that?
Chair Peters, Ms. Bodkin, we actually have submitted a policy option package for electronic health records to include not only the startup component, but then as we work forward, figuring out the subscription rate and to receive funding for that.
And the only other thing I would add is the legislature did approve a POP package last legislative session to allow us to do an RFP, or at least the original legwork in the analysis for the EHR. So this would be phase 2. Yeah.
So I guess my question is, if it was legislatively mandated, would it give you more leverage to get it done?
Chair Peters, Ms. Bodkin, well, I don't know the answer to that.
If we were required by statute to have electronic health records?
The only reason I say that is because if it was legislatively required, then it seems to me that, one, it would be easier to get ongoing funding, but two, it wouldn't fall off the table in subsequent administrations that, not that I think you're leaving, but, you know, I mean, but.
Do you know something I don't know?
No, no, but I mean, I'm saying that, you know, another director may not have the same commitment to this that you have or that your current staff have, and it would be a shame to just not have it in place forever. You know, it makes sense to have it. It makes sense to have it for a whole bunch of reasons. But it makes sense to have it forever, not for biennium to biennium to biennium.
I think the issue of electronic records, whether we're talking DOC or OYA or any of those that have, as we move forward in the whole reform of medicine, electronic records are at the center of this as a way of trying to reduce as much as possible duplication of effort and to be a little more collaborative in actually treatment. So, but I don't know how, even when you mandate, as you know, from this, the policy side, the bigger question becomes is the financial side in order to carry out the mandate. And so, you know, we you know, Colette's correct in you know, offering up the policy package, and hopefully dollars can flow with those policy packages. I'm not going to say anymore because I don't think she's leaving.
No, I don't. I didn't mean to suggest that, but I'm just saying. I mean, I was just thinking that, I mean, I agree that it should start with OYA. It actually should start with counties. You know, I mean, counties ought to be able to have this so that we have, unfortunately, we track these people from our local governments. And so, you know, it would be helpful if everybody had the same information, but.
I do think, Ms. Bodkin, that this work group's commitment to electronic health records and actually making it a recommendation out of this work group will speak volumes to the members of the legislature as we ask for additional funding. So I think you are helping in that vein.
And I would like, as we actually make those recommendations, that we have a broader statement that actually includes looking to the future counties, because you're correct, Ms. Botkin, that you know, there is a need for the counties as well. If we're going to really do a comprehensive job, that piece should be there. It's just like everything else that we connect when we're talking about the criminal justice system. We do it with LEDs and what have you. It seems to me that from the medical side, that too should be a connector. So you can't do it without talking about the other jurisdictions.
Agreed.
Well, and I don't want to beat this to death, but over the years, I've heard numerous complaints from our members who do the intake of inmates that data is lost because it's not electronically transferred, and sometimes all the papers don't get moved with the inmate that they need, and it can delay things. And so, you know, if we had it electronically, it would make it much easier on the staff as well.
No doubt, and there's duplication. I mean, the
Yep.
counties are testing them for the exact same things we're testing them
Yep.
for because we didn't receive the paperwork. So we have committed, to the extent that the technology out there will allow us to lease a system that can connect with folks in the community. So that has been our commitment. As you have all read in the paper, it's been difficult to find that one system that does that in a really fluid way. But we continue to commit to that as we look for the best program for the Department of Corrections.
Okay, I won't beat it up anymore.
But it'll be noted in the report.
Thank you.
Thank you.
So a follow-up item, I'd like to provide for the work group 2 updates regarding reports published by Pew Charitable Trust specific to the issues of correctional health care. First, if you remember, I testified in my role as budget manager for the Oregon Department of Corrections back in November of 2013 about my concerns with the data included in the 2013 Pew report entitled Managing Prison Healthcare Spending. It had contained data that did not accurately represent the increase in healthcare costs for the Oregon Department of Corrections. It compared costs in 2001 to 2008 and showed a 245% increase in cost across that time frame. And we determined that that number was not 245%, but was actually in the mid-20% range, which puts us right back in line with the other states. And I'm just pleased to report that we've worked with Pew and that they have updated their report with our corrected information, and we've provided a copy of that for you with your materials today. Second, Pew has just released a newer report this month entitled State Prison Healthcare Spending. We've provided you copies of that report for your review as well. Contrary to the previous report's issues with numbers, we feel that the numbers included in this report are accurate. In this latest report, there are a number of interesting takeaways that correlate directly with what this work group's been discussing for the past 8 months. First, comes as no surprise, most states saw an increase in healthcare spending from 2007 to 2011. Interestingly enough, in the aggregate, though, if you look at the entire cost for the nation, they actually saw it move down a little bit due to a huge inflation-adjusted modification by the state of California. But if you look nearly across every state across the board, you're seeing an increase in cost. Second, Oregon ranked 10th in the nation for inmate healthcare costs per inmate per year. Now, one of the things to remember is you've seen a lot of different reports from Pew and from other resources as we've gone through this. I just wanted to call out the fact that in this one, it not only includes the cost for the Health Services Division for the Department of Corrections, but also includes alcohol and drug treatment numbers in these. So sometimes you're seeing one number for what's our annual cost, and then you see another number, what's our annual cost. It's just because of what is specifically included. In this specific report, alcohol and drug treatment are included in those figures.
DA Sparks.
Chair Peters, Steve, is the cost in the other states also inclusive of A&D?
Chair Peters, DA Sparks, yes, it is. As far as I know, according to the methodology of the study.
And I think that's an important thing to note, because I think Oregon was unique during the recession in that we held on to alcohol and drug treatment, where many other states did not. Programs and treatments were slashed across the country. And so as you see us ranked a little bit higher, that's not necessarily a bad thing, because it does include those numbers that we were able to hold on to through legislative support.
Finally, Oregon ranked highest in the nation, and this was a surprise to me. We were highest in the nation in terms of the average share of inmates over 55 years of age.
And that surprised me too.
As we've discussed, this population in terms of physical age is far more expensive to treat. And the report makes this direct correlation on page 12 of the new report, talking specifically about this over 55 population and cost. We continue to strive to keep our costs down, as this work group can attest to. So the data is supporting what we've surmised, and that is we have the largest share of inmates over 55, but we've been able to manage that to the degree that we are not the highest cost per inmate on an annual basis in the country.
So, Madam Chair.
Yes, Ms. Bodkin.
Since other states have sentencing policies that are, in some cases, harsher than ours, how is that possible?
Chair Peters, Ms. Bodkin, I can't speak to the other states. I will say, I was quite frankly, I knew that we had a significant population. I didn't think we were number one in the nation. That was a surprise to me.
And the data was taken between 2007 and 2011, correct?
Chair Peters, Senator Warren's correct.
And we don't know what changes have occurred in some of the states. When we look at the sentencing reforms that have occurred in Texas, Arkansas, and some of those other states, how much of that would have reduced that population? So I think there's probably some other variables that are probably in play.
No doubt, and this report is still warm, so it was just released. So this is something that we're looking at DOC to see, is it length of stay? Are we receiving a higher number of elderly folks at intake, or is it because we're keeping them longer? So we're trying to understand kind of the specifics behind it. I do know that Oregon takes very seriously violent crimes and sex offenses, and we know that people don't age out of those crimes. People don't age out of sex offending. People don't age out of those very serious kind of in the heat of battle violent crimes. So that could be reflective of our intake population as well, but we'll be looking into that. Go ahead. DA Sparks. Please.
Oh, well, I actually just had the question, Chair Peters, that perhaps we're taking better care of our inmates, or I don't know that the cohort when they arrive is generally healthier, but if you compare us to other states, the inmate cohort might be less healthy on arrival, and depending upon the care they receive in the institution, might die earlier. Just have just less longevity because they're maybe eating high fat, high salt diets that, aren't prepared as carefully as the diets that we have here at the DOC, or other things that address their overall health needs. I'd be curious, I don't know if we can dive into that at all.
Did the
but-
report speak to the average lifespan of an individual incarcerated?
No, not specific to Chair Peters.
Interesting.
Not specifically to lifespan, but it does definitely draw the correlation that we've all been speaking to theoretically, and that is the fact that when these folks, first of all, they're coming to us sicker than the normal population, and that this more elderly, quote unquote, in this case, population is definitely more cost intensive for us once they hit the door.
But it's a question we'll pose. I've added it to the list. It's one I hadn't thought of. Ms. House?
Thank you. My question was about the issue that you just spoke on of what percentage of our Oregon inmate population is serving mandatory minimum sentences, and how those mandatory minimums might compare to the mandatory minimums imposed by other states. And I would imagine that such a comparison has maybe been pulled together already by perhaps the Oregon Sentencing Commission. But if we had access to that data, it might be interesting just to shed some light on the trend that we're seeing here in Oregon and how that might interplay with other legislation that's being considered. Perhaps our committee might have a recommendation on that.
Great, thank you. I don't have that data here, but we can certainly bring it to the next meeting.
Thank you.
Okay, thank you.
That was pretty much my question. I was just going to ask how much of the population over 55 was under Measure 11 or sensing guidelines, so.
I think also to add to that, how many is Measure 11, but also to add to that the severity of crime. I suspect, and I could be wrong, but we are talking about, when we've looked at the snapshot before, you had a higher degree of predators and what have you in that particular category than you did in others. And so that information would be helpful as well to see what the sentencing is and the mandatory minimum
And the crime behind it.
and the crime behind it.
Okay, we will definitely add that to the list of follow-up. Director Fox-Rest?
Is this an appropriate time to be asking questions about the report itself?
Absolutely.
Okay, thank you. And Steve, I don't know, I don't expect you to know the answers to these, but on page 7, the report talks about consolidated data systems, and it cites South Carolina converting their accounting system into a consolidated system. And they're citing 70 other state agencies. Now, I don't know if they're actually talking about a consolidated system overall or just within correction agencies. It would be interesting to look to see what they've done and if we can learn anything from that experience. So that's one. Page 8, they're actually talking about 3 different drivers for healthcare costs. Age is one of them. But the other 2 that they talk about is the distance of prisons from hospitals and other providers, and then the prevalence of infectious and chronic diseases, mental health, and substance use disorder. I just wondered to what extent could we look to see to what extent those other, actually all 3 of them, are driving the cost. I know we have remote facilities. Maybe it's not an issue for Oregon. I mean, this is the challenge with aggregate data because, you can't really arrive at conclusions. I mean, it's kind of even hard to arrive at a hypothesis, just as D.A. Sparks said, what's the quality related? I mean, my costs can be pretty low, but if I'm not providing care or high quality care, I'm going to pay much more later down the road. Then the other thing that I had a question was, they talk about the high rate of hepatitis C in prisons, page 9, and I just wondered what the situation is in Oregon, and if we could look into whether or not we're trailing or hopefully not leading the nation in that. And finally, does the DOC cost include DOC inmates at Oregon State Hospital, or is that a different cost? So those are my questions from the report. Thank you.
Chair Peters, Director, we'll put that together for you and issue those answers to those questions out to the work group.
Perfect. All right, thank you.
Chair.
Yes.
Thank
Chair.
you. Mr. Robbins, I did have an observation regarding page 10, a rather dramatic graph there. The number of state and federal prisoners aged 55 and older increased 204%. And you can correct me here whenever. In 1999, I just, some napkin math, percentage of prisoners 55 and older as a representation of the total prisoner population, about 3.3%. In 2012, that rose to 8.7% for a percent of total inmate population increase of 5.4%, which is not as, that's not as dramatic an increase, but for one observation. Two, it doesn't take a huge increase for expenses to really take off. So for me that was helpful. I mean, the rise isn't as dramatic, I think, as the Pew makes it appear, at least graphically, but it's still true, even if it's just a 5.4% representation or increase of the total population. It represents a dramatic rise in cost.
Thank you. Director?
Just one other observation. When you look at page 12 and you look at the percentage of population over the age 55, and then the average healthcare costs, I found it pretty interesting because you look at a state like Minnesota with 5.1% population over 55, and their healthcare spending is actually higher than Oregon with 12.4%. And then you look at a state like Wyoming, which still with an older population lower than Oregon percentage-wise, but much higher. So it's just interesting. Again, you can't arrive at any conclusions in the aggregate data, but I hope Pew's going to dig into this stuff further because we cannot answer these questions until we know some of the deeper variations in this data and what's causing these huge variations within the state.
But I think some of the questions that you posed earlier will actually contribute to that conversation. I think when we talk about, and you're going to talk about this a little bit more even this morning, our chronic disease management program, the Hep C program that we've now had in place for over 8 years, I believe, that have helped contribute to the not the reduction in costs, but kind of capping the growth of those costs. So I think you're pinpointing some helpful specifics.
Thank you, Chair. I have a question that's raised by this reference to page 8 relating to a portion of the cost being driven by the distance of prisons from hospitals and other providers. And one thing I'm experiencing in my practice as we've seen this switch from the Oregon Health Plan to, at the risk of sounding somewhat educated here, I'm going to call them community care organizations, although I don't think that that's what they're called. Is that right?
CCOs?
Okay, CCOs.
Very good.
And what I'm seeing in some of my clients' experiences, at least out of custody right now when they're on pretrial release or otherwise being supervised in the community, there is some disconnect that they're experiencing, say, if they're out of county, at a residential drug treatment facility and needing to connect with a physician in the area, there's a wait, there's a difficulty in connecting with healthcare services when their county of residence is not their county of supervision. And I have no idea whether this is something that's impacting healthcare services in the DOC right now, but it strikes me as a factor that potentially could bear weight on this first factor of the location of the prison and the location where the healthcare services may most efficiently be provided. Is that an issue, and if so, should we look further into it?
Chair Peters, Ms. Hose, I think that one of the things to remember is for us, a significant component of our healthcare costs is that off-site care.
Right.
And so depending on For instance, the east side of the state, and I think the data will bear this out, and we'll pull some of it for you so we can give you some actual information. On the east side of the state where we're having to take folks, in some cases even over the border, there's costs associated not only with the healthcare component, but with the security component and the transportation component and all of those. So I think there's clearly a correlation for us in those cases. Specific to your question about issues with access to care, one of our charges, we're constitutionally mandated to provide that access to care while they're in our system. So that would not be a limitation for them while they're in our system. We will find them, and in some cases, we will relocate them to a different part of the state if we have to get them the proper services.
Well, maybe rephrasing my question then, are you finding, since we've had this shift in how the Oregon Health Plan operates, have you been experiencing any additional difficulties in connecting that inmate with care in the community?
Chair Peters, Ms. House, no, we have not.
Okay.
And I would just add that while everything is not fluid yet, I think OHA's vision is a fantastic one. I think that there have been really great collaboration in this process, and their vision really is that the CCOs would actually do reach-ins like parole and probation officers do before they even leave, which would just be fantastic because, as you well know, transition and reentry is difficult anyway, and then add on top of it that they need to meet with their mental health specialist and their general care practitioner because they are over the age of 55 upon release. So that once we get to that place where those reach-ins are consistent, I think we'll even see a more fluid process in the community.
Thank you.
Thank you.
Just-
Go ahead, Senator.
No, go ahead, Senator.
Just to follow up, and hopefully, and I think it'll be helpful, particularly when you mention some of the other costs, when we're talking about the facilities over in Eastern Oregon and what have you, where you've got transportation and access issues and what have you. So hopefully we're going to get a snapshot of those, because I don't think, from a legislative perspective, that, some members understand that the cost may be different in the valley and the metropolitan area where you've got access and don't have the same kind of transportation needs as if you're talking about, particularly I'm talking about the Sea and Snake River and perhaps having to go to Boise or Umatilla and having to go, and those do pose some challenges as well as, the understanding from this side of the aisle that we have 14 cities, I still call them cities, that are around the state, and not all areas of the state do have, quote, CCOs that are very active and what have you. And I think that does have something to do with cost in the various regions. One region may be higher than the other region because you don't have neither the access nor you've got transportation and security issues that you wouldn't have.
No doubt, and I think the only thing I would add is Mr. Robbins also struggles with hiring the appropriate professionals in those remote areas, which then again adds to our costs when we're not able to have that internal staff and we're having to move adults in custody for care.
Yeah, because we've been talking on this side about the whole issue of not having professionals and adequate staff in the rural communities.
That's right.
And this is another piece of that, so.
Ms. Bodkin?
I was just going to ask Steve if it is possible. If it is not possible, I don't want you and your staff to break your necks to try and do this, okay? Is it possible to get a institution by institution analysis? Because I have a sneaking suspicion, just off the top of my head, having made the drive several times, that Lakeview might be a little more challenging than any of the other rural institutions. But, that's just a wild guess on my part. Transportation, trying to find, I don't know, a quality doctor willing to live there.
Chair Peters, Ms. Bodkin, the interesting thing for me as I am still fairly new to health services is to find that some of those correlations aren't as direct as you would think. For example, if you look at our huge overtime costs for what we call hospital watches, are actually at Columbia River, which is one of our smallest institutions in Portland. And you would think, why is that the case? Well, it's because the most serious medical cases that are going to the OHSU are requiring security, and so Portland is the one providing it, even though that inmate spent their whole incarceration out at Snake River. So it's a very interesting question that you ask, and it's one that we continue to try and break down, and I think perhaps as I'm just thinking through this, one of the things we can do to help the work group understand is use a couple of examples. Here's an inmate, specific inmate that went off. Here are off-site. Here are all the specific costs that were associated with that, not just the medical component, but the transport component, with the security component, the overtime component, all of those different things, so you can at least see through a couple of different examples what types of costs are associated. In the aggregate, I think you're right. It would be very difficult for us to do that across every institution and every off-site visit, but maybe if we can provide a bit of a sample for you, that can at least lead to some other questions that we can answer.
Well, and if there are specific challenges with some of the rural institutions, I mean, you and I have had conversations, as have the director, I mean, about challenges that we have in these rural areas. You know, it was all well and good to build these institutions to create jobs in rural Oregon,
Until September.
but along with that came a whole bunch of challenges that we now have to face ongoing, year to year, budget to budget, and it's easy to cut $30 million out of the corrections budget. If you're doing it here, it's a lot tougher when we have to live with that cut out in the field. So, you know, I'm just trying to figure out ways to leverage a better argument for us.
Absolutely. Chair Peters, Ms. Bodkins, thank you. I think one of the other things I'll mention, I don't want to open up a whole nother can of worms here, but we have actually just met last week with OHSU specific to their telemedicine offering. So we're continuing to look at technology opportunities here where perhaps there is some of this medical workload where we can actually have an inmate with an electronic televideo examination kiosk at a location out in Ontario dealing with a doctor that's actually at OHSU in Portland. And we've met with them and started conversations about their offering and what the potential solutions are. We've also queried all of our staff, asking them from your perspective, what do you see are some options there as well? Because I would say, along with what Director Peters says, we're seeing less problem with access to care for off-site and specialists out there than we are with getting staff and hiring and recruiting in the provider markets especially.
I can't understand.
Did I see a question over here out of the corner of my eye? No.
Well, now that you turn to me, I always have a comment. But I just wanted to say that everything that's been said also applies to OYA at a smaller scale.
Yes.
We are experiencing the very same challenges, especially when it comes to medical professionals, you know, psychiatrists, psychologists, to a lesser degree nurses, dentists. So, you know, again, but we are much smaller than DOC, but our experience is the same.
Thank you.
Question, does anyone know whether rural health and that committee is also addressing or working on the issue of recruiting providers and what have you? Because it's an issue for the state, not just for DOC. And how we're going to address this issue now and in the future. But it is
An issue.
an issue.
Absolutely.
I don't know the answer to
Oh,
that, Senator,
check
but we can
with
certainly
that.
look into
We'll
that.
follow up.
And we'll report back at the next meeting. Okay, thank you.
Good.
Okay.
Okay.
Before you move to the next slide, I should have done this earlier for the record. Dr. Norwood Knight Richardson has joined the work group. Good morning, welcome.
Good morning. Thank you.
So as we've done during the previous work group discussions, we're going through the various recommendations and next steps. And during this work group, we plan on covering the final three. And these are the final three: the possible early parole release restructure, health incentive programs, and tracking and measuring healthcare coverage upon release. So the first topic relates to the possible early release of specific inmates as a cost savings measure. In some conversations, this has been referred to as geriatric release or compassionate release or medical release. I understand this is a topic that elicits strong opinions, so perhaps as a way of beginning this discussion, I can share with the work group a quick history by way of providing information that was presented to Ways and Means during the 2013 session. Today, under current law, medical release is a limited option if the inmate has not been convicted of a Measure 11 crime and housing and care is available to the individual. It's a collaborative approach with judges, the DA, parole board, and victims. The process is very thorough. One of the pieces of information that you've been provided is titled briefing paper, and so I just wanted to call that out for you. The first 2 pages of this talk about the early parole release process, and the 3rd page actually lists the statute that is kind of the overarching statute for what we're talking about today. In this process, first, a request for consideration must be received. This may come from an inmate, it may come from staff, it can come from a family member, friends, or members of the community. The health services case manager then verifies the medical condition and sentence eligibility before the DOC medical director reviews the case. We then gather counselor reports, institution history. We solicit input from the judge and the district attorney and notify the Board of Parole at that point. It's just a trigger to notify them that consideration is in progress. Then we do a second review to ensure that we've captured all data accurately. The DOC Executive Committee, which in this case is the DOC Medical Director, the Superintendent of the facility where the inmate is housed, and the Assistant Director of Operations, then reviews the case to determine if medical release is compatible with the best interests of the inmate and the community. If approved, they advance the case to the Director for review, the Director of DOC. The Director reviews the case, and if she supports consideration, she sends the request to the Board of Parole. The final decision is made by the Board of Parole to grant or deny medical release, and the board can set conditions and time of parole. Now on this slide, the last point you see there in 2013 and 2014, I wanted to just give you some information on what the actual numbers have been. So in 2013 and 2014 to date, we've had 20 inmates that were referred for consideration. Of those 20, 14 had sentencing restrictions that precluded them from early release. Of the remaining 6, 3 did not meet the medical criteria. 2 died before medical release was initiated, and 1 was denied by the Board of Parole. So in terms of this, there's one additional piece I'd like to just call out and take a moment to discuss, and it's a unique situation specific to the issue of what we would call comatose or vegetative state. When we look at ORS 144.126, it presents a challenge when it comes to an inmate who is comatose or in a vegetative state. The current practice has been that the inmate is dying before consideration is given for release, and the inmate must meet the statutory requirements regarding sentencing. So under current practice, there is limited potential savings given the fact that all the appropriate and necessary care has been provided prior to the fact that they've been determined terminally ill. The ORS 144.126 doesn't speak to someone, just as an example, who's in a vegetative state and is 25 years old and is anticipated to live to the age of 70. And because they aren't considered elderly and they aren't considered terminally ill. And so I just wanted to call that out as one of the interesting issues here that we're dealing with. I will also call out that even if we do try and address that, kind of that uniqueness of that specific issue, please remember the number of inmates in our custody that would apply to is extraordinarily small. We currently have 1 inmate that might qualify under the comatose/vegetative state status. He's a quadriplegic, but doesn't qualify for consideration due to the sentencing components of the statute, due to his being sentenced for rape and sodomy. So all of those things combined make this specific issue just one that's unique amongst many unique issues in this conversation. So having provided a little bit of that background, I'll return to Chair Peters for further conversation on this issue.
Great, thank you, Mr. Robbins. Questions, Ms. Bodkin? None?
No, he answered my question.
Okay, fantastic. So what I thought I would do is we've gathered a list of committee members' questions that were raised about this conversation, either on the record or via email. And so if we were to consider expanding this, if we were to consider one example of expanding the language to comatose and vegetative state, if we were to consider expanding the number of inmates who are allowed via their sentencing requirements. These are some of the questions that you all have asked along the way. I'll just highlight a few of them. What is the minimum age before an offender is considered, right? As an example, we said 25 years of age and in a vegetative state. Currently, there is no minimum age for offender consideration under the current language. What impacts would the program propose to Measure 11? Would this work group want to make any recommendations around recommending any changes around early medical release as it relates to Measure 11? How will the local concerns or opinions be considered? Currently, as Mr. Robbins pointed out, the medical transition case manager solicits input from the case judge and the district attorney and submits their response to a comprehensive report presented to the DOC executive team and ultimately to myself and the Board of Parole and Probation. Some other interesting ones. What is the approximate number of applications annually? I would like to point out that while there were 20 referrals, and we talked about all of the subcategories of people that either died in our custody, weren't allowed under the given statutes, did not meet the medical criteria, the number of releases was 0. I just wanted to make sure that everyone noted that all those little numbers added up to 20. And that was an annual count. So right now, while there is a process, we aren't in reality releasing people under this provision. Let's see, what other one did I want to highlight? That one, and I just covered it. So if anyone has any questions, wants answers to any of these questions as it relates to the current law, I'm happy to do that. Other than that, I would like to open it up to the work group for discussion around the potential modification of the program as it exists. DA Sparks?
Chair Peters, members of the group, I actually would like to see written answers to these questions. I think these are absolutely critical questions to be answered, and I think before this group can really make sense of where the, where we should land, it would be good to see what we've got factually.
So I'm happy to go through them all right now on the record to help this conversation, then we can get the answers out to you in email following this meeting.
Certainly, that would be fine. I mean, obviously, we'd like to see, speaking on my own behalf, I'd like to see backup data, facts and figures. I don't know if you have those at the tip of your fingers, but...
Let's see what I have. We'll walk through them. Okay, great. So I'll start at the top. What is the minimum age before an offender is considered? Right now, the answer is there is not one.
Chair Peters, I'm
Yes.
sorry if I can interrupt. I just had a question. I understand the statute does require that the inmate be elderly. How is that defined? And does that not, in fact, impose a minimum age where there's not technically a minimum age? We do see an elderly classification here.
At the Department of Corrections, and I don't want to offend anyone who might be of this age sitting at this table, at the Department of Corrections, because individuals come to us 10 years older, biologically, compared to their chronological age, we actually determine the age of 55 as being elderly. I don't know, Mr. Robbins, how we define elderly for this specific conversation. Is it 55?
Chair Peters, yes, it is.
Okay.
Thank you.
Great.
Well, and Chair Peters, if I can make the observation, the statute breaks it into two groups, suffering from a severe medical condition, including terminal illness, or elderly and permanently incapacitated in such a manner that the prisoner is unable to move from place to place without the assistance of another person. So I
Thank you.
would interpret that as having no age requirement on the severe medical condition component.
Thank you. Good clarification. again, the question related, what impacts would the program propose to Measure 11, if any? Again, that would be a conversation here. Currently, Measure 11 offenders are excluded from this conversation. I answered, how will the local concerns or opinions be considered? I shared with you how it is done currently, as did Mr. Robbins on the record. If we wanted that to be more extensive, should we expand the program? You certainly could make that recommendation, no doubt.
Madam Chair?
Yes, Ms.
I'm
Bodkin.
sorry. Let's bounce back to the Measure 11 change. Is my Government 101 class falling short here? Isn't that a constitutional issue? So making changes to ballot measure 11 would ultimately have to be decided by the voters.
So
Or two-thirds, could two-thirds of the legislature overrule?
they could. I don't think that this recommendation would make
don't think
changes
we
to the
change.
Measure 11 statute. It would make changes to the early medical release statute.
Okay, I'm just, okay, I don't know, I mean, I
Or-
don't know whether there would be an argument.
I guess there could be an argument. Yeah, there could. Yeah, that's right.
Sorry to interrupt,
Ms.
but
Moan.
I think the way that the statutes around ballot measure 11, because it says notwithstanding any
Right.
other
Yeah.
statutes,
Good point.
You would have to change measure 11
Right.
as well, if that was. the
That's right,
path.
because it would be an early release.
I think
DA
that's-
Sparks, that's what your face was saying too, I think, correct?
I
My
think
face
that's
and the rest of me.
accurate.
Yeah.
Yeah, I
Good.
think that was my
Yeah,
concern.
no, I think you're absolutely right.
Any change.
If I may interrupt one more time and say another potential consideration here, if Measure 11 by Constitution is, we're not able to make any recommendations to amend Measure 11 such that those offenders would be eligible for this early release program. Another angle to consider, I know the legislature very frequently considers extensions on the statutes of limitations, which allows prosecutions of inmates for a longer period of time under Measure 11 statutes, and that's something that we can consider. For example, if an offense is committed when someone is 16 years old and they're then 37 years old when they're finally prosecuted, that's something that could be a factor contributing to an aging inmate population. Perhaps I can loop back around and say that might be something worthwhile considering, along with the other data that I asked for with respect to how our state compares to other states with respect to these mandatory minimum sentences, and how we compare our statutes of limitations to the limitations, the time limitations of other states, so that we can see, to what extent is Oregon imprisoning offenders for these mandatory minimum lengths of time that perhaps are imposed very far beyond the point of the actual offense. Just something to take into account.
Great, Mr. Shoemaker. Noted. Thank you. Doctor?
Quick question. What percentage of our inmates on Measure 11, do we know?
I want to say it's around 50%.
That's what I
Hello?
was thinking.
I believe it's around 50%.
50?
Yes. But we can verify that at the next meeting. Senator?
It would be of interest, and I think I already know the answer, but anyway, for the panel. And that is the percentage that are non-Measure 11, that are actually 55 and older, that actually fall in the category. That what we're talking about. And then, because I think the discussion then following that will be the crime behind it. So, it would be nice to have that we get into the non-Measure 11, those that are under parole, to the age of the age factors, and then also what are some of the medical conditions.
Right, so who's at the tip of this
Can I
conversation?
put a little finer point on that? I think it would be helpful to know what the crime at original conviction was.
How is that?
Because I don't want to know I don't want to know a parole violation.
Right.
I want to know the crime of conviction that ultimately
them there.
caused the long sentence.
And why do you, I'm curious, why do you want to know that?
Because I think that tells us a little more about the inmate and about the challenges that we would face in the release of that individual.
So
You
if you're
know,
75 years old
If
and
you're
in a
75
vegetative
years old in a
state,
vegetative state,
and you're back on a parole
and
revocation.
you're back on a, yeah,
Yeah.
all right, you know, and.
Well, if you're in a vegetative state, I want to know how you managed to violate your parole.
That's,
Failing to report to your supervising officer.
sleepwalk, they gave him Ambien.
You know, I mean, I'm just saying, you know. But I do think that the crime of conviction sometimes is helpful just to know.
Well, the reason, Madam
Please,
Chair,
Doctor.
The reason I was asking about that, I sat on PSRB for almost 7 years, and often just knowing the crime really didn't tell you much about the individual unless you understood the facts behind the crime and what went on there. And there are so many mitigating factors that I would not want to have a judgment regarding an individual's ability to be released without a thorough review of the records, which in some cases you end up looking at the records from the trial. So it gets to be a very thorny issue and must, perforce, I believe, be pursued on an individual case basis so that we don't end up with an overwhelming prejudice just because it said rape or assault against individuals who have been sentenced under those particular.
And I believe you are spot on. I think that the crime of conviction tells us how many thorns we're going to run into with victims and the community.
That I would
You know.
agree with you. It's
You know,
true.
I mean, I just think, you know, when we're looking at this, it helps to know what the whole landscape is. And I do believe people have the ability for redemption.
Yeah.
But you know, I just assume not have them coming after us because we released a bunch of people that they don't, you
They
know, that we
should be
didn't
reading.
understand.
Right.
You know, so.
Okay, so we will gather the data and present it at the next meeting. Director?
Just a quick question, you know, context, of course, always matters. So when we're talking about early release for someone who can walk out and be free is much different for someone who cannot, you know, does not have command of their, you know, bodily functions and ability to function, etc. So the very first thing I want to know is what is the size of this pie? And the other question that's related to that, because this committee is focused on healthcare costs.
That's right.
The question is currently, if you have someone within the OC that you're caring for in this condition, if that person is committed to a care home, would they become eligible for Medicaid funding?
Chair Peters, Director, the answer to your last question is yes.
Okay.
They would.
So based on that, I mean, it would be helpful for us to know what is the size of that
Right.
pie. Like, you know, if we are only talking about a handful of people, then really is it worth our time and effort to be focusing on that versus if there were significant savings balanced with the safety. And I know, you know, there are other things like truth in sentencing and all the other things, but I think if we have a starting point to know what are we talking about, we can work our way back to determine whether or not it's worth our while to move forward.
Great, thank you. I think the questions asked earlier will get us to that source. DA Sparks?
Chair Peters, I would like to know, in reading this, I don't see that there is any organized function for victim input. Is that, am I reading that correctly, or?
No, what we, in this process, we reach out to the district attorney, and that's usually where that victim input comes, is through the DA. Typically, the DA is checking in with the victim's family, and then that's formulating the DA's opinion around their stance on the release or not.
Well, given the victim's constitutional prerogatives, rights, it seems, just a suggestion, but it seems very important because victims, it may come as a surprise, can completely disagree with the district attorney.
Right.
And it happens not uncommonly. And they may want someone to stay in or they may want someone released. And that, I think, should be a part of this process, given the constitution of this state, that the victims have their own voice and their own right to appear by counsel and to ask questions in any hearing that might be held, separate and apart from the district attorney. I mean, we have this in the parole board. Right now, I appear all the time in parole hearings, and it just makes sense. Victims sometimes show up, they want to appear personally.
And that's true for the PSRB.
I'm sure it is.
And I think that's a good suggestion, really.
And then let's also ask, because while we didn't call out victims, and I know that I'm familiar with conversations that we've had with DAs that have talked about the victim's opinion and recommendation, can we verify with the parole board that that then does not happen at that final stage in front of the parole board already? Otherwise, I think you're right, having this work group recommend, and I'm seeing heads nod across the dais, having this work group recommend that one of the expansions be victim input called out statutorily, I think makes sense. Does anyone object to that recommendation? Okay, great, noted. Thank you.
Chair Peters, I'm
Yes.
sorry, I have a second question. Just
Please.
kind of relates back to the idea of having Medicaid pay for these folks, if we could. Is there any possibility to contract with a third-party provider if as the point was made by our director over there, if we have the ability to contract with a large enough group with a third-party provider in what would be a secure DOC, perhaps a secured facility, but the provider would be an independent. Is that something that
It's
we
something
could
we've
do?
researched and looked at.
Yeah,
Mr.
Chair
Robbins, you want
Peters,
to take a stab?
DA Sparks, I can speak to that as well. The problem we run to is the federal requirement, the fact that that person is incarcerated.
Right. Yeah.
That's the problem that we run into. And because we've looked at some of the other states, I think Kentucky, for example, is doing some work around state-run off-site medical facilities, but you've got correctional officers there. It's a secure facility, and if that's the case, it's precluding them. So that's one of the problems they're running into as well on the Medicaid side, is if it is a secure facility and they are incarcerated, then they cannot qualify.
And we even pursued it under the analysis under House Bill 2087, which allows us now to collect Medicaid for those inmates who are in hospital more than 24 hours. And what we quickly realized is that those medical doctors will not make a determination to keep them in hospital longer than that hospitalization is required, so it can't be a long-term solution. They're not going to make the decision so that we can collect Medicaid, but we also pursued that and posed the question. So.
And Chair Peters, if I may just add one more thing really quickly, and that is, I'd mentioned in the very first slide, we talked about applications for Medicaid and the fact that we've bumped up against our first that was denied. I don't have all the specifics here right now, but I know that some of that was related to the fact that the inmate wasn't able to sign documentation because of their state. So there's so many different elements of complexity as to even if we were to work through that, we'd have to work through all of these various elements with OHA as well. So.
May I follow up with another question?
Please.
Is an inmate maintained in his or her secured level? Let's say they're maximum security, and then they become extremely ill, and they're being treated, and they're disabled. There's no need to keep them at that level. I'm assuming you collect in some sort of hospice facility folks who don't need that type of security, so that at least their costs are reduced by that factor, the reduced security.
Chair Peters, DA Sparks, that's correct. We typically, in our larger institutions, we've got 5 infirmaries, and those folks that are needing infirmary care, we have various levels of security at each of those, but depending on the case, for instance, with the inmate we currently have that's comatose and in vegetative state, we are incurring extra medical costs there just because of the need for specific care, but on the security side, no.
And then the other thing that we found in looking at this analysis is that our hospice program is relatively inexpensive. So all the medication that we've been spending money on and all the procedures we've been spending money on stops when they're on hospice. It's an inmate peer program, so it's an inmate who's trained to sit with that individual and help provide that care. And so it's even a lower level cost than it would be if it was medical personnel. And so all of the high medical costs end once we start the hospice program. But we asked the question, would it be cheaper to run the hospice program in community? And the answer was no, because of how we currently operate it inside.
How many do you have in hospice now?
Chair Peters, Senator Winters, it varies. I could give you a specific number, but at any one time, I think there can be as many as 5 to 10 across the network.
Thank you. Ms. Bodkin?
Okay, so my question is, my mother-in-law, God rest her soul, suffered from dementia and Alzheimer's. We put her, in the end, we had to put her in a facility that was every bit as secure as Columbia River is, because she was an exit seeker. It was very secure, getting in and getting out. How can, and she got Medicare while she was there because it's a, quote, healthcare facility. Why can't we do that? Why can't we say, okay, we're gonna like create these little, I mean, if we can do it for Alzheimer's, why can't we do it for inmates? I mean,
And our DOJ...
and I don't know it would save money, I'm just saying.
Our DOJ counsel was unable to join us this morning, but so I'm not a lawyer. I will just pretend to be one for a second and channel him. I think what he would tell us is that we would have to change the statutory definition of what incarcerated means, because as the feds interpret that, if you are incarcerated, your Medicare eligibility is suspended.
But and that definition is not just incarcerated in prison, because that also includes individuals who are in the state hospital. It is written in a way that if it's institutional, that states are responsible for, you do not get Medicaid. You know, I've said that before. States have been wrestling with how do we find the loophole.
Right.
It's written to save the feds money.
Absolutely.
Ms. House?
Sorry. Would you like to go ahead and pose your
It's okay.
question? Okay. I just want to clarify, Senator Winters, if I understand you correctly, if some of these individuals were released but remained on supervision, and a condition of that supervision would be that they resided in a secure medical facility, if they were required as part of their supervision to reside at that medical facility, which is a secure facility, it would be akin to the Oregon State Hospital, where the state is responsible for their care, and therefore they're no longer eligible for Medicaid. Is that right? Yep. Okay.
We have been, and so has Ms. Botkin and others, and have been wrestling with this particular issue for a lot of years.
15 years at least.
And it's one where it was designed to save the federal government money and to shift the cost to the state. I mean, let's be honest about what we're talking to. It was a huge, where we were doing 60-40 before, it becomes 100% for state and institutions. And so we have really wrestled. When we passed the legislation that allowed us to use Medicaid for if you're out of the institution over 24 hours in the hospital, that was legislation that was passed last session as one vehicle to do some cost savings. And we really have been trying to look as creative as possible as to how we can actually solve this problem. Oregon is not alone. No. Other states are also looking, because as we get more geriatric individuals, the cost of medical care goes up, and we're just all wrestling with this particular issue and dilemma. So I talk to your congressman.
Mr. Miller? Sorry to keep you
Well,
waiting.
I think the only point that I was going to make is that the problem you have with moving them out into residential care would be that you have to move security staff with them. And by statute, I believe, in order to be, under the supervision of Department of Corrections and supervised by security staff, have to be certified. And then you've just created another institution, basically.
Right.
Correct. Yeah, thank you. Sheriff?
Thank you, Chair. I just have a clarification question relating to RS 144126. Mr. Robbins, when you were describing it, I heard you use the term comatose and vegetative state a few times. I'm wondering, is that to define kind of 1B, elderly and permanently incapacitated? Trying to figure out where that language as a constraint on the program.
Sure, Chair Peters, Sheriff Garrett, I think it's in A and B. And the reason I say that is when we talk about severe medical condition, I think there's not a ton of clarity around specifically what that means as well. So I think it falls into both cases. We just called out this specific issue because it's one in which a lot of times the example is given, well, if you've got somebody that's just sitting in a coma, then why are they continuing to stay incarcerated? And so we've had that question posed to us enough times that we usually like to just call it out that this is a specific example of one where even if that's the case, if you look at our population, and we'll get more information for you on our population at large, but as you start to narrow down and get into who can actually qualify for this, it's very, very small. And unfortunately, in those cases, in the case that we only have one, and he's got Measure 11 limitations. So I think that issue of comatose and vegetative sort of permeates both of them.
Okay. Yeah, because if I just read 1A, suffering from a severe medical condition, including, but not requiring terminal illness, that seems to open up the candidates a bit. But if in practicality it's much more restrictive than that, then so be it.
Chair Peters, Sheriff Garrett, I'd also maybe would like to refer that to DOJ as well, because I know that some of our position on that is coming from direction from them.
That would be really useful.
Great,
Thank
so
you.
we can follow up with that as well. Okay, thank you.
So, may I ask a question?
Of course.
Julia on the phone with Visitor Base.
Hi, Julia.
Hi. So one question is when we look at healthcare costs and obviously the reduced cost of hospice, and we're talking about patients who are long-term comatose and the care is involved with that. Are we getting, or do you know what percentage of patients are giving an advanced directive in the inmates? I mean, are we getting that, or is that part of the, is that being factored into this? Are we getting those advanced directives from inmates?
Mr. Robbins?
Chair Peters, I know that I don't have specific information for you, but I can get it for you. But a vast majority of them we do have advanced directives for.
I continue to learn something new every day. Okay, moving back to the questions. We've talked about how many applications appeared annually in the presentation. The next question is, of them, the number that were approved. I'm going to call that out again, even though we covered it. There are only 1 to 2 cases a year that meet all the necessary criteria to be granted EPR due to their serious medical condition. So I'll just call that out again, but we'll review that data in more detail at the next meeting. Of the requests for consideration made over time, what's the general breakdown that come from the adults in custody, the offender, family members, friends, community members, etc.? And I understand that you have that information, Mr. Robbins, so I will turn to you.
I do, Chair Peters, members of the work group. The information that we shared on the slide that was 2013 through current year-to-date 2014, there were 20 inmates referred for consideration. Of those, 50% were referred by health services staff. So that could be a provider, it could be a nurse, it could be anybody in the health services staff. 30% of those were referred by the inmate themselves. 10% came from family, and 10% came from other institution staff. So somebody in security or somebody in administration in the institution.
Thank you. What's the approximate duration to process an initial request form through final decision? From the time of receiving a request for consideration to actual release can take from 7 days to 3 to 4 months. And so that's a pretty wide span. It really depends on how quickly the application gets moved forward through our chain of command, how quickly we can get in contact with the district attorney and the others that we're required to contact. The Board of Parole and Post-Prison Supervision is the sole decision-making authority, correct? Or the answer is correct, that is correct. They are the sole decision-making authority with input from DOC, DAs, and others. Can you please describe the means by which the judge and DA provide input? We discussed that earlier. The judge and the DA receives a letter via fax and mail, and I receive those responses from them in writing by email or a simple phone call. All responses are then entered into the comprehensive report.
Chair Peters.
Yes, ma'am.
Thank you. I'm curious as to the impact that the move toward evidence-based sentencing is making on these kinds of considerations as we're looking more and more at recidivism rates and psychological examinations and real sort of evidence-based reasons behind keeping somebody in custody beyond the point where they're, maybe they're not in a comatose state, but maybe they've reached such a state of their health or physical condition such that they no longer pose a danger. To what extent is that being taken into consideration in this process?
I think as it relates to the current process, that's not something that's taken into consideration.
Okay.
The reformation piece is not part of the statutory language. It really is risk to society, risk to public safety that's taken into consideration.
And to what extent, though, is sort of data supporting that, other than just sort of health staff saying, this guy's in really bad condition, we could consider him for a medical release? Is there sort of empirical data, psychological data, anything like that that's being considered, not on the reformation end so much as just sort of whether or not this person is in fact a risk to the community?
I will tip it to Mr. Robbins, but I would say there is empirical data. I think we are looking on a case-by-case basis. We are looking at the medical diagnoses, both medical and mental health. Mr. Robbins?
Yeah, Chair Peters, I would agree with that. I think the other thing many times people ask us the questions in correctional health care, how do you treat cancer? How do you treat Hep C? And we always have to answer, it's really, we don't look at these large classifications of diagnosis. We're looking at individual cases. They all have very different backgrounds. They have very different crimes. They have very, but from a medical perspective, as we look at whether or not they're quote unquote incapacitated or it's all done on an individual case-by-case basis. Clearly, we try to operate from the standpoint of data. It's difficult for us to have anything really empirical specific to that, but we try to understand based on the body of knowledge that we have in front of us. Our medical director and the folks in DOC are trying to make that decision with that included. I know that's not a very specific answer, but that's as specific as I can give you.
Thank you.
Thank you. Is there a question over here? Okay. So that ends the list of questions that we have managed to. Any other data points that you would like for the conversation for next time around? I'm clearly hearing a desire from this work group to continue this conversation for the next meeting. If you think of any between now and then, don't hesitate to send an email. Any other recommendations that the work group would like to consider as it relates to changing or expanding this statutory eligibility right now?
Thank you, Chair Peters. I'm curious, as I'm comparing everything to other states today, to perhaps look at the early release statutes and procedures that are employed by other states, and whether there is some sort of measurable success to those programs. I am troubled by the rate of release. Just looking at these last 2 years, having 20 applicants and 20 denials, and it does strike me that there ought to be some some room for making this work here. And if there's a state that's making it work, I'm really curious about how they do that and what their law looks like and what that looks like back out in the community. And I don't know if that's something that's data that's easy to access or if that's going to require.
Ms. Howes, I believe it is. I believe this is something that we've already collected.
Oh, great.
Mr. Robbins?
Yeah, I don't have it specifically in front of me, but I think we can certainly pull together information for you and provide that.
Fantastic. Thank you.
Great, thank you.
Senator? Stephen, when you put that information together, and I know we've done some snapshots, and I suspect that I may not be accurate, but I think one of the big pieces in not being able to do early releases has to do with Measure 11. I'm just going to put it out there on the table, and that's why I asked for, to separate out, Measure 11 and what's happening from those that are on parole and probation that are not Measure 11. I think you'll get a better snapshot and a picture of that. But certainly, the discussion of Measure 11 takes us into the constitutional piece, takes us into what has to occur, to go there. But and other states may not have the language of a measure the same as we have. So those are other factors when we're looking at other states and their early release. The other piece that probably will have a significant play, I think, from other states, and that is the sentencing reform that was been done in other states that was not done at the same, we can't compare apples to apples and oranges to oranges. If I look at what Texas and Georgia and others did in order grappling with this, it's not the same as what we did. So, I mean, those are actually, but it's something you can ask Pew about, since they also were involved in the sentencing reform that was done in some of those other states, and whether or not that's had an impact on early releases, particularly on the medical side.
Mr. Miller?
Okay, and I do have one question, and I haven't thoroughly thought this through yet, but is it cheaper, it's obviously cheaper for us to house inmates in a minimum setting versus the maximum security. Would it be cheaper to take care of some of these inmates that are in a vegetative state in a minimum setting versus the maximum security, or is it with all the assets that are already available and therefore, like, say at the OSP infirmary, I think probably your now that I think about it, your cost savings would probably deteriorate trying to reduplicate that in a minimum setting.
Yeah, Chair Peters, Mr. Miller, that's exactly right. We're looking at needing infirmary level care for these folks, and so that right there automatically limits them to 5 of the biggest institutions as well. One of the things we have been investigating, though, is, for example, we do have a number of quadriplegics in the system, and they are currently housed in multiple locations. And so we're looking at potentially drawing that small population, even though it's a group of only 4 or 5, into one location, and so that we can use only one set of nurses to do that. Part of the reason that hasn't happened is all the other things that occur in the correctional environment, which is programming and other things. We don't want to hurt those inmates by doing that. So, but these are things that we're continuing to look at. Is there a way for us to do this in a location where we have the care, where we can provide it at most efficiently? So we are considering it.
Steve, you just opened up the door for me. Are you also looking, along with the paraplegics, those 5, of also looking at some of the, maybe combining some of the geriatrics with it on a facility that has 1 floor?
Single floor facility.
Chair Peters, Senator Winters, the answer is yes.
Thank you. I won't go any further.
The senator and I thank you. We've only been harping about this for how many years, Jackie?
Well, and I appreciate your answer. The difficulty is, and we've talked about this over time, the one facility that we have available is OSPM. And as we look at how much it would cost to retrofit that facility to a medical facility for geriatric prisoners, it's substantial. It's really substantial because once you start modifying a building, you have to get it up to ADA standards, of which that facility is not.
I'm going to take one step at a time.
Okay, fair enough. I'll stick with Mr. Robbins' answer. Yes, we are
Yes,
exploring.
we are
and
looking
I'll
into
stop.
it.
Good, that's a good answer.
Any other recommendations or data sets that this work group would like for the next meeting? DA Sparks?
Chair Peters, I think I've heard that on the left-hand column, what medical eligibility criteria must be met to be considered from disease to cognitive or functional impairments. And I've heard that it's case by case, essentially. But there have to be common themes. And I just think that case by case is not a very strong answer for us. I would like to know, if it's available, what has been used. For example, of the 20, what sorts of information did you pull together and consider before those 20 were subject to evaluation? And I realize for the 14, it was probably a pretty short set of questions because they were not eligible.
Chair Peters, DA Sparks, the other thing we'll provide for this group is we do actually, although we do look at it on a case-by-case basis, we do have some guidelines that we use. And in answering these questions for you in writing and as we come back to you, we'll go ahead and include that as a part of it as well. Kind of the decision-making process for our medical case manager as we go through that process.
Are there, if I may?
Yes.
Are there any OARs that govern that process? Just under the
Director Peters,
statute?
DA Sparks, I don't believe there are, and I think that's one of the reasons why I didn't bring it today specifically. I want to be able to share it with you, but in the context of the fact that I don't think we really have a lot of guidance from statute on it.
I think you did a sort of a step down, I mean, a process. Could you recreate that and get it to us in writing? I mean, I think you were reading it.
On the 20?
Yeah, you said this is the process that we use.
Oh.
Here's where we go, here's who's in the decision making. You know, you said at each step there's,
Yep.
here's what we do.
Chair
And
Peters,
if you could provide that, that would be really
Sure,
helpful.
Chair Peters, Ms. Bakken, just so you know, first, this is at a higher level, this briefing paper, which is in the packet of information you have, walks down many of those steps.
I don't.
And if you don't have that, we'll certainly provide one for you.
Oh, I don't have that. I have that now.
Oh,
Thank you.
I didn't, but I do now. Thank you.
Okay.
Well-
Anything else?
It occurs to me that one possibility would be if legislative counsel, or I'm sorry, if your AG advising you thought it potentially fruitful, is for there to be some notice and comment rulemaking under this particular area of authority that the DOC has, because if you have no real guidance, it might make some sense, and that would give certain groups the right to weigh in, anybody who really cares about it, and there may be lots. I wouldn't pretend to know all of them. The other question I had is, I don't know that, we've really touched on, it says for some release, will there be a secure alternative nursing or assisted care home? And I think there's a lot of interest in that answer, even if it were private, because if an individual is completely unable to walk away and at the same time Medicaid eligible, that's a better spot to be than if the person can just walk out the door. And it also ties back into mobility issues and whom are the inmates who are considered.
Thank you. Anything else? All right, seeing nothing else on this topic, we will turn to recommendations and next steps around the health incentive programs for adults in custody. Mr. Robbins?
so in terms of health incentive programs for adults in custody, I'd first like to share some examples of how inmates' participation in our chronic disease self-management program, or CDSMP, is growing and succeeding, and then I'll cover DOC's process for generating new ideas in this area. The CDSMP program is born out of Stanford University-based curriculum that involves incentivizing inmates through their own participation and training of peers who have chronic health problems. The program involves workshops that deal with techniques to deal with issues such as fatigue, frustration, pain, isolation, also dealing with exercise, medications, communication, nutrition, decision-making, and how to evaluate new treatments. In this program, inmates are helping inmates, and I receive regularly letters from participants thanking me for this program that we have. We have Dr. Ann Shindo on our staff who's implemented and oversees this program, and she's doing amazing work for us. The best part about this program for me is that we don't need to provide a widget in order to get participation. In this case, just the simple fact that we're providing them the autonomy to lead their own peers, that's something that they don't get in their environment, and that is in fact an incentive. And by the growth of this program from institution to institution and the rate at which it's growing, we know it's clearly been successful so far, and we look forward to continuing to grow it as a means of incentivizing folks to take personal ownership of their chronic disease issues. Second, as DOC's embarked on what we call organizational transformation, or our journey of CORE, which is correctional outcomes through research and engagement, which is our process for becoming more transparent in our operations and turn the agency into an outcome-based organization, we continue to delve deeper into the possibilities for improvement based on data. Just last week, we've had very difficult discussions internally about how to incentivize, implement, and measure the concept of wellness, something that we've been talking about with this group over the past 8 months. We've had very constructive discussions around the difference between wellness and the treatment of disease. And these conversations obviously stretch far beyond the health services division into the other areas like nutrition, education, the exercise, canteen, things that we've just covered regularly here. And those are outside of the health services division, but they're obviously important components towards achieving that balance and life balance of wellness. I bring this to your attention because it's an example of how the work of improving inmate health care and the benefit of the outcomes of that work are going to be conversations that not only continue today, but will continue beyond the life of this task force and work group. And for us, I'm pleased that we are incorporating this into this core process, because what it really means is I don't have a list for you today of these are all of the incentive programs that we're looking at using, but we actually have the machinery built of which to start to generate those ideas, incorporate them into the fabric of our agency, and also to make sure that then we're able to measure them and use data to determine whether they're things that we should continue to do or discontinue doing as we move forward. So there's going to be more to follow here in the years ahead, but I'm excited because this work group actually allows me some ammunition in those conversations to talk about how we can move these things forward that are traditionally not just purely medical issues.
How many of those groups do you have now?
How many of the CDSMP groups or of the core?
The previous one, the peer-led groups.
Oh, the peer-led groups? Oh, that's a good question. I could get you the specific numbers on it. I know that we're not in every institution at this point, but we are already in the planning stages for having them in every institution.
And do they go through any formal training?
Correct. Yes, they do. And again, I'm not an expert on this area, but because it's Stanford-based, they're very specific in their criteria, the training that occurs for not only. There's multiple levels of leaders in the process to include sort of master level folks and then the folks that are teaching their own peers or leading their own peers through it. So there's definitely a stair-step process for that.
Okay.
I'm curious, I actually think this is great stuff, okay? I think this is really good stuff, and I'm really glad that you're doing it, and I'm glad that the department's doing this. I'm curious as to, I mean, you said you're going to try to track them after release. I mean, how many of our inmates do you think are going to like it if we track them after release?
Ms. Pocket, I'm not specifically when we talk about tracking them through release. You're referring to what?
You said you're going to track, measure, and measure healthcare coverage upon release.
Oh, I think, actually, I believe that's going to be the next topic.
Oh,
And
okay,
we'll
I'm
actually,
sorry,
that's
I'm
okay.
sorry. Oh,
We'll
I
actually have
jumped
somebody come
ahead.
up and specifically address that, yeah.
Okay.
Because we're actually going to try
I
and
read
do it.
ahead.
Yeah, that's
Right.
right.
Okay. Anything
great.
else?
All right, I'd like to introduce Cindy Booth from the Department of Corrections to address the final recommendation.
Thank you, Mr. Robbins.
Thank you, Mr.
Appreciated
Robbins.
your
Thank you.
presentation very much. Ms. Booth, welcome.
Thank you.
Hi, Cindy. It's so nice to see you again.
Thank you. Good morning. Chair Peters and members of the work group, for the record, my name is Cindy Booth. I'm the Administrator of Transition and Reentry for the Oregon Department of Corrections. I'm here today to share some information regarding the department's efforts to track Medicaid and other insurance eligibility at release from prison for adults in custody. And ta-da. As reported to this work group during your June 9th meeting, since late February of this year, the department has been enrolling newly eligible adults in custody for Cover Oregon and for Medicaid services upon release. We use the Cover Oregon portal to actually enroll individuals 7 days prior to their release from custody. Their eligibility is known to the department at the time that they release, and we're able to share that information with both the individual and with the community corrections agency that will be supervising them upon release. There are separate processes and requirements for persons who are under the age of 64 at release versus those who are age 65 or older at release. The department does actively enroll individuals in both Medicaid processes. If the person is under the age of 64, again, we use the Cover Oregon portal. If they are age 65 or older at release, it is an assets-based Medicaid pre-qualification process that actually begins 75 days prior to their release from prison. DOC manually tracks all Medicaid applications for the department using an Excel database currently. We are working with our IT services to develop an electronic process that will allow us to better track and share that information with our stakeholders at release. In the meantime, we are able to track both the application process, the individual's eligibility, the reasons why they were not eligible, if they were not, and to share that information with the Oregon Health Authority should they find it necessary. Briefly, individuals are eligible for Medicaid coverage through the Oregon Health Plan of Cover Oregon if they are under the age of 64 and meet the the eligibility requirements. Persons who are age 65 and older are not eligible if they have assets that exceed $2,000. This income assets-based application process also requires the person have a birth certificate prior to their release if they were born outside the state of Oregon. And I recognize that this conversation came up earlier with regard to the department's efforts to ensure that all individuals, regardless of age, have a birth certificate in their release file. We are working diligently to capture those who are going to be releasing who were born outside the state of Oregon to back that process up so that we have it in the file for use in pre-qualification for Medicaid as soon as possible. With regard to measuring coverage at release, between January 1st and June 30th of this year, DOC released approximately 2,577 individuals. In the time that the Department of Corrections began using the Cover Oregon portal for persons who are age 64 and younger, we've enrolled approximately 85% of those individuals, meaning that they were eligible for Medicaid at release. If they were not eligible, it's because they were releasing to out of state, or they were over the income limit, or they chose not to apply, or their family members were already enrolling them on the Cover Oregon plan that the family was enjoying. Similar statistics for those who are age 65 and older with regard to the reasons that they may not be eligible. The income limit is significantly more strenuous, the $2,000 limit. Again, if we don't have a birth certificate and they were born out of state, we're challenged, although we try to get it within that 75-day window. Some people choose not to accept Department of Corrections assistance to pre-qualify for Medicaid services upon release, and we can't require that they accept our help, meaning that they refuse to sign the consent form, for example. And then many of the individuals who are age 65 or older may have other insurance options available to them. And so to apply for Medicaid prior to their release would actually not benefit them. Approximately 26% of those individuals who were age 65 and older at release were found Medicaid eligible for their release window. Again, we learn from the adult and people with disabilities department within Department of Human Services whether or not an individual is eligible prior to their release. And I believe that's it. I'd be happy to answer any questions.
I don't have any questions, but I have a comment.
Thank you. Yes.
And my comment, I just want to thank you and the Oregon Health Authority for the work that has been done, and in a very efficient fashion, I might add, because it hasn't been that long that we passed the enabling legislation, and we wanted to make certain that there was a smooth transition and work between the two agencies. And I want to say a thank you to both of you.
Great, thank you, Senator. I appreciate that. It has been a great collaboration. We knew it wouldn't be fluid and perfect, but the collaboration was. I mean, it has been just a constant going back and forth between the two agencies, and we're really, really grateful for the partnership. It certainly has been a partnership. Thank you. Any other comments? All right, thank you, Ms. Booth.
Thank you.
Appreciate all of your work.
You know, it'd be nice to hear from the counties, or even through parole and probation, sometime in the future, of what positive impact this has made, because we have moved from releasing individuals with no actual abilities to have medical service to a system now where we're talking about prior to release and the consistency of going through. I'm specifically thinking of mental health and some of the challenges that we've all talked about with that population. And so it would be kind of interesting, at some place along the line we get some feedback from their respective counties on how that's working with them. So.
Great, we can touch base with OACCD and the sheriffs and see if it's time, is it too soon right now for any data points? But I think you're right, Senator. I think this whole notion that someone might have mental health treatment or alcohol and drug treatment upon release or prior to being incarcerated in the first place, I think there's great potential for a reduction in victimization. So it's something that we're trying to track and monitor at DOC, no doubt. Yeah. Okay, so for next week, we will continue our conversation around early medical release. And then you will actually get to look at a draft report that we'll get out to you prior to the meeting, and we'll be able to discuss the contents of those reports and that recommendation. And then hopefully we'll be able to finalize our conversation around early medical release after receiving a presentation around all the additional information you requested. DA Sparks.
So the report that we're going to receive, the proposed report, is that going to contain proposed recommendations?
It will.
And maybe I've missed the point of the discussions today, but I thought at our next meeting we would produce those. I don't feel
No,
like
let me
we've
be,
got
let me
any
be specific.
recommendations.
It will include recommendations around all the 11 out of the 12 topics, not the one on early medical release. The only recommendation that I heard from the work group around early medical release was potentially exploring more direct input from victims. I think that's the only one that was on the table today. Mr. Shoemaker, were there any others? No? Okay, thank
Thank
you
you.
for the
No.
clarification. Okay, with that, thank you for your time this morning.
Thank you.
We're finishing a few minutes early. That's always better than a few minutes late. So thanks, everyone, for making the trip.